Today we were in front of Judge Mulway because the Army brought a motion to dismiss. In other words, they were saying that there was no basis to our claim that the Army failed to comply with two settlement agreements that were entered into over the years to get information to the community. Back in 2000, the Army and Mālama Mākua entered into a settlement agreement that not only required the Army to do an environmental impact statement under the National Environmental Policy Act, but specified certain information that had been burning questions to the community for years. One of those questions is, this is a valley that's full of sacred sites, and to what extent would a return to training, something that the Army's proposed to do, destroy sites that can't be seen with the plain eye, what lies beneath the surface? Because we know at Mākua, from past archaeological investigations, that there are many sites that lay just beneath the ground. So you've got emu sites that date back to the 1400s and before, you've got house sites, you've got implements, you have signs of life. They give a clue into what the valley was like before it was converted by ranching and military training. And the community did not want that information to be lost. And so part of the settlement agreement said that there needed to be comprehensive subsurface archaeological studies of all areas within the training area. And we want answers to those questions. And we were challenging the Army's failure to provide that information as one of our claims. Another question left unanswered is, what is the effect of military live fire training Mauka on the resources Makai, on which area residents depend for subsistence, on the limu, on the fish, on the shellfish, on everything that the ocean provides? It's a common saying that the ocean is the icebox of the people who live along the Waianae coast. Well, people who live there want to know, is our icebox being polluted? Is it being contaminated by the training that's happened in the past and that the Army proposes to do in the future? So our settlement agreement required that the Army provide information about these two topics, and we specified it in the 2000 settlement and then in a follow-up settlement that was entered in 2007 to make sure that the Army wouldn't shirk its obligation as a neighbor to give a full accounting of its activities to the people in the surrounding communities. Unfortunately, the studies that were put out as part of a final environmental impact statement that was issued earlier this year had nothing in it. And we went back to court to hold them to account, to hold them to their promises, and ultimately to make sure that the people of the Waianae Coast and the rest of Oahu and the rest of Hawaii get real information about what the effects of live fire training at Mākua are. So today, the Army went before the court and argued that as long as they put out a stack of paper that had the title Marine Resources Study on it or Archaeological Survey on it, no matter what was inside, even if it was just blank pages, that they would satisfy their agreement, that they would satisfy the promises that they made in 2000, 2007. And the judge sent a strong signal that she just didn't buy that. That doesn't pass the straight face test when you're asking someone, is this really what you agreed to do? Is this really what Mālama Mākua intended would be its benefit of the bargain through the contract? And so while we're awaiting the judge's decision, which she promised would be issued within the week, we're hopeful that the end result is going to be that ultimately the people of Hawaii are going to get the information to which they're entitled.
One of the things I noticed that they really focused on was the letter of the law of a contract and not the essence of the initial agreement or discussion, or even the sense of that discussion and what was important to the community. What's your take on that?
Well, my take on that is that, basically they were spouting principles of law which are valid. A contract needs to be clear with respect to what is required of the parties. That's a fair statement. But to then take those principles and apply it to settlement agreements that don't just say, Army, do an archaeological survey, or Army, do a marine resources study, but instead specify particular types of information that those surveys and studies have to provide, is just a misapplication, and I think that the judge saw through that. I mean, she asked a wonderful question. She said, all right, you were told to do a study of marine resources. What if your study was interviewing people after a luau, at which they had some fish and limu from Mākua and nobody got sick? And what if your study said, well, if it was contaminated, we'd expect someone to get sick, no one got sick, and therefore there is no military-related contamination. Would that be all that you need to do? And the lawyer said yes. And, she's a good judge. She keeps her cards close to her chest. But the framing of that question suggests strongly that she understood the point that we were making, which is that the agreements don't just require a study or a survey. Rather, they require studies and surveys that provide a particular type of information. And when you scrape beneath the surface of the conclusions that they put in their study, so their study said, you know, there is some contamination here, there's no contamination there, but when you scrape beneath the surface and you see what work they actually did, I mean, the contract says you need to study and test limu, on which area residents depend for subsistence. And they admit in the study that they sent people out to Mākua who had no idea what limu they were gathering. They didn't know not only what species it was, but even what genus of limu it was, what type of limu it is. The one thing they knew for sure is it wasn't edible. Well, when you have a study that says you need to figure out what the effects of military training are on people who rely on resources for subsistence, and you study the limu on which they rely for subsistence, it's sort of first principles that you need to gather limu that people eat. And so we're confident that the judge is going to see through that, and we're going to get on to the meat of this case, which is proving that the Army failed to do what it promised to do many years ago.
Well, just a little bit beyond that, we had peers review their study, methodology, results, conclusions, and they commented that it was lacking.
Right.
And so they had all of the things that needed to be filled in before we even got this far. So are they ignoring some of the community, the comments, even from their peers?
Yeah, one of the things that was unusual about the settlement agreements that we entered into with the Army is that we tried to structure them in such a way to make sure that we would get good information. So often you get into a situation where you get an agency to agree to do a certain kind of study. They then go and do the study. They spend all the money that was appropriated for that study, and they come back with the final study, and you say, that's not what we wanted to know the answer to, or this has a fatal flaw, or you're studying this kind of limu and we eat that kind of limu. We didn't want those problems. We weren't trying to play gotcha. We wanted good information, and so we structured the agreements in a very unusual way. For the Marine Resources study, we said, before you spend a dime on actually carrying out the study, put your study protocol out for public comment. And on top of that, give us some money, because we're representing Waianae Coast communities that don't have those resources themselves. Give us technical assistance funds so we can hire some peer reviewers to take a look at the study protocol and let you know if it'll give good answers to the questions that you need to answer. And so we went through that process, and we didn't play hide the ball. We hired some very qualified people who said, you're studying the wrong species, or you're looking at the wrong background sites, or why are you looking at this, not at that? And we were very specific. So the Army had an opportunity to adjust course from the get-go and make sure that it got the community the information that it wanted. But instead they decided to sort of put their head down and go straight ahead and try and get away with, as their lawyer said, a study, rather than what the agreement requires, which is a good study that provides good information.
So, hope for the future.
There is hope for the future, but it's not over yet.
They're trying to reinvent procedure all the time, and when you bring like a real fact, things that are affecting the community, problems, and they're coming and they say, no, we did this, we did that. So how do you see like you're trying to reinvent on procedure all the time? How do you do that?
I think you need to do both. I mean, what the Army is trying to do is it's taking a situation in which if you looked at the facts as a person in the street, as just if you pulled someone over and you said, let's take a look at this study and let's look at the basis study, do you think that's what you were supposed to do? And your average person without a lot of legal background or a lot of scientific background would say no. It doesn't provide any meaningful information. So the Army knows it's faced with really bad facts. So the last refuge of anyone with bad facts is procedure. This is the wrong way to bring your suit. You should have done it this way. You should have done it that way. If you, judge, you need to take a very narrow view, a narrow construction of the contract, and that's all that we're held to. But don't worry, Judge, they can challenge it some other way, some other how. That's what you do when you have lousy facts. Now, my job is to always bear in mind that judges are human, and humans like to see rational, reasonable outcomes to situations. So my job is to focus on the facts and how there's a disconnect between what the agreement clearly says and what they produced. But I also cannot ignore the fact that judges are lawyers who are used to looking at procedures. And so I have to be sort of a master of both and advocate both, which is why I also pointed to the exact provision of the 2007 settlement that reserves our right to challenge before the court the adequacy of the studies. So you've got, hopefully, we'll see what the outcome is, but hopefully you've got the common sense, man in the street response, which is something doesn't look right here. And you've also got the lawyerly response, which is, and you know what, they have an avenue for redress.
My name is Ryan Kapuniai, and I attended the hearing and I have a question. If the animal life in Makua Valley is contaminated, and if people eat those contaminants, from a legal perspective, what's going to happen if humans start getting sick from eating the contaminated animal life?
What we were trying to accomplish in terms of the settlement that we structured in 2007 was initially to provide high-quality information to the community on the Waianae Coast who depend on these resources, because there's certain things that we know. We know that for years the Army used some of the areas at Makua as an open burn, open detonation area, and that simply put means they disposed of munitions there by blowing them up in place, not contained in any way, and our concern was spewing contaminants in the process that would then wash down into the ocean. We also know that they've done live fire military training there since the 20s and then ramped up again starting with Pearl Harbor. We also know that in addition to the live fire training, they've used a lot of chemicals over the years for herbicides to control the vegetation growth, to try and do fire management chemicals. I mean, just a lot of stuff up there. And it's not a very deep watershed, and although the Waianae side is dry, anyone who's been out there knows that when it rains, it pours, and when it pours, a lot of soil, a lot of things come down, large boulders and contaminants and all the rest of it. So we were trying to respond to a need from the community to know, is it safe to eat that fish? Is it safe to eat that limu? Is it safe for my children to play in the shoreline there because little kids put sand in their mouth, and they wanted to know, is it safe? And for years, the Army had kind of poo-pooed those community concerns and said, oh, there's nothing to worry about. And so in 2000, we structured a settlement that said, okay, you deny that any chemical constituent could possibly get off the boundary of that reservation. We don't personally think the chemicals know where the boundary is. We think they just flow downhill. And so the first phase of study was to try and figure out whether any chemicals of concern were coming and crossing the boundary into the public area. And so they did some studies during the rainfall events. They were able to measure surface water. And when they measured the surface water, they found some surprising things, at least surprising to them. There were 40 plus chemicals that were coming out of that stream, everything from RDX and perchlorate, which are specific to munitions products of their explosion, all down the line to things that one would associate with the herbicides that they've used. And when you recognize that they're the only entity that has controlled that valley since Pearl Harbor, if there are herbicides coming down, they're related to the military activities. So the second phase was, if they found that type of contamination, they needed to do the studies that were the subject of today's hearing, which is, how bad is it? And we broke that into phases. Are the marine resources taking up contaminants that are associated with training? So let's look at those 40 plus chemicals. And if so, evaluate the extent to which that's just a feature of a fish or limu you'd gather anywhere in the state because our waters have some contaminants in them, or if it's special to the military. And then if it's special to the military, to what extent is your proposal to return to live fire training that's going to add to the pollutant load going to harm people? So we were just trying to look for that basic information. Your question seems to touch on whether the Army has some additional liability for the contaminants they've placed. That strikes me off the top of my head as probably a Federal Tort Claims Act related claim rather than a strictly speaking environmental claim that I'm not qualified to answer. So what we're trying to do is just kind of get to the first stage of the inquiry, which is what's the harm, what's the impact, both in terms of what they did in the past, because we'd never gotten good information, and looking forward, the decision that they need to make based on the EIS is, should we return to training? We wanted to know the extent to which it would continue to impact the community. And because that type of thing may not be of great concern to the Army, but I can assure you it's of great concern to the community and their elected officials, who ultimately in this democracy are the ones who decide what the Army does.
I noticed that Judge Mulway mentioned that you could also seek remedy through the NEPA process. I was wondering if Earthjustice planned on doing that.
Well, that was kind of the Army's thesis, was that we could not directly challenge the studies without challenging the overall EIS. And I don't think that there was any basis for that claim, both because the settlement agreement specifically provides for that. And I mean, there's just nothing in the settlement agreement that would limit us to that type of relief. Now, she has been the presiding judge on this case for the last 9 years, and we've been back in front of her several times to enforce various parts of the settlement agreements. And so occasionally she kind of jokes about how it's nice to see us all again and that type of thing. I think she was just stating the obvious, which is, we're certainly, there's a potential for a lawsuit directly challenging the adequacy of the EIS. And we haven't brought such a case because we believe it's premature. Under the settlement agreement, they shouldn't have even gone final with the environmental impact statement until they had done various studies and incorporated them. And so the relief that we're seeking, and in her inclination, she indicated that she would be open to granting, is basically telling the Army, you issued your final EIS too soon. If she finds the studies inadequate, she would be open to ordering them to go back to the drawing board and come out with a new EIS. And so our view was, we have a very focused, narrow claim here that should be quickly resolved. We need to bear in mind that the Army currently is talking about wanting to resume live fire training at Mākua as early as January of next year, so in a couple of months' time. So we wanted to get in front of the court as quickly as possible with a narrow claim that we felt was very strong as to why all of that should not go forward. And then that would render moot, if she rules in our favor, it would render moot the adequacy of this EIS, that will be pulled and a supplement will come out. And if they have the benefit of additional time to prepare these additional studies, then hopefully they would take advantage of that time to cure some of the other problems with the EIS, which we've been very forthcoming about in comments on the draft EIS and the supplemental draft EIS and the final EIS. They know where the problems are, and hopefully they'll fix them. So, my hope, my goal, is that someday this will no longer be a case for the court of law. It'll be purely a case for the court of public opinion. But in order to get there, the public and its elected officials need the information to make a rational choice.
This case was a motion to dismiss, and the defense attorney implied that he would like to convert it into motion for summary judgment, and you said that you wanted to do discovery, and I was just wondering what kind of things you would hope to find in your discovery.
Well, as far as, I was glad that the judge seemed to resist the notion that we would get blindsided by a conversion of a motion to dismiss into a motion for summary judgment, because in that context we'd have the opportunity to present expert declarations. We already know what we think about these studies, because as part of the process we have the technical assistance funds to retain peer review, and they submitted comments. I mean, the Army doesn't have a mystery about why we have a problem with these studies. We had experts that submitted lots and lots of comments at every stage of the process, telling them what they were doing wrong, again with the hope that they would correct course so we wouldn't have to be back in front of the judge on it. As far as the discovery, we want to know what they really think about it, because the discovery, and we've already propounded the discovery, and they tried to block the discovery, and we were in front of Magistrate Judge Kobayashi last Monday, where she said, unless the case is dismissed, you'll be providing that discovery by December the 2nd. So what we want to know is their internal emails, their honest appraisal of why it is they didn't test any limu that people actually eat, why it is they didn't test the same species at Mākua and at the so-called background locations, why it is when they got these comments they did not correct course, because our suspicion is that there's going to be some very damning information, hopefully some candid comments that'll make it through their review, that will shed light on the fact that not only do we think that they were doing a bad job, but they knew they were doing a bad job too. And it's always easier to win a motion when both sides are agreeing on the facts and it's just a question of the law.
Yeah, I've got a question. I thought it was really interesting how this case almost, as it was going on, it almost turned into a contracts case in a way, and that was really interesting to me. And I was wondering, for a lot of us aspiring environmental lawyers, how often do, certain issues like that come up into, we're studying environmental law, but it turns out, maybe it's a contracts or a torts or a civil procedure case. Is that pretty common, or, okay?
You should pay attention to all of those courses. I highly recommend it. Because, ultimately, environmental law, the history of environmental law is based in tort law, right? So these are statutory enactments of things that the tort system wasn't able to really address properly. But that doesn't mean that you need to forget that there are tort causes of action, that depending on what type of environmental law you do, you may find a need to draw on. As far as the contracts aspect, it's black letter law that when you enter into a settlement agreement, as we have with the Army, to resolve a dispute, it's a contract. So you need to know what those principles are. You need to know the extent to which you can rely on extrinsic evidence, so things from outside of the four corners of the agreement to interpret it. All those things are come into play. And so in civil procedure, the judge in the post-argument phase was talking about the local rules and really knowing all the ins and outs. You'll notice that one of the arguments that I made was under Local Rule 7.4, they should not be arguing that we're limited to a NEPA lawsuit, because they didn't argue that in their opening brief, and they can't blindside us in the reply brief. I guess the only exception to that would be if it went to a matter of subject matter jurisdiction, which the judge would be required to raise on her own if she felt it was there. So you'll note that I then said, and if you do consider it, they're wrong because of paragraph, I believe, 17. But anyhow, you're going to want to be facile with all that sort of basic stuff. I think.
Aloha, my name is Leandra Wai. I know in Ahupua'a of Kahana Haiki, in the ili of Laihau in Mākua. I, for a long time, have been a part of Mālama Mākua, at least since 1996, when the Army, when the state evicted the last of the houseless at Mākua. And then I became very involved after living under 3 years of military occupation in Mākua, where they had, for 22 days a month, practiced live fire. And it was very disturbing then, tents flashing and with each explosion, seeing red flashes of light going into Mākua, and sometimes waking up the next day and finding the whole valley burned. Anyhow, I got involved with Mālama Mākua because they were going to court to sue the Army for information over environmental concerns. And so in 2001, there was an agreement to cease fire until an environmental impact statement was created. So for all that time until now, I was really hoping and praying that there was some kind of consciousness in the whole system to provide good science. I thought maybe they wanted to know too whether their activities had left the environment toxic. So today was really revealing. All the time I was feeling like they didn't really care, but the words and the people in front of me showed me a sense that like they did care on a personal level. But what I found today was on a bureaucratic level is that they didn't care. I think his name was Shapiro, the JAG, the civilian JAG. He said, well, yeah, if they're only obligated to provide a report. Not that the report had anything of sustenance, but that they provide a report. So Judge Maui was really cute. She said, if I caught one fish and I came to the conclusion that it was of no hazard to the public, then they fulfilled their requirements. And at that moment, I remember sobbing inside. And every time I think about it for the past couple hours, I sob again, because I realize all these 8 years of hoping and praying that there would be some consciousness for good science was an illusion for me. They really had no intentions of providing good science. And I think that is the worst thing for me right now. How are we going to mitigate that? Somebody so big and controls most of our money and a large portion of the land that I love and feel sacred for. How are we going to mitigate what the Army is doing or wants to continue doing? Just give us a blank piece of paper saying, oh, we looked at it, it's okay. We didn't analyze it, but we weren't required to analyze it. I tend to be laughing right now, but I don't feel very happy about it.
Even the agreement seems to be clouded by how each person interprets the rule and then how they behave. Bad attitude, good attitude, mean, gentle. How do they treat the cultural practitioners that enter Mākua to do cultural access?
What I've observed for me on a personal level is that they appeared to care by saying the right things and performing basically just saying, okay, we're concerned about that too and we're looking into it. What it's come down for me is that they really want to get rid of us, this environmental group. So they've labeled us in many different ways. And it's all about the person standing in front of us, not what law dictates, or not what the settlement dictates, that they should make way for us, allow us access, be environmentally concerned. They're not into that. So with each new passing person, and they never stay very long. Some are nice and accommodating, and some are get da 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 out of here. Okay? And so recently, since they've started to absolutely deny access, they've kind of flipped all over the place. It's not wearing shoes because you might get hurt. Stepping. No, it was part of a verbal agreement. Today, it's since December 2008. It's now in writing. You know, you got to watch out for this, because even if it's in writing, it doesn't mean anything until they have it in their hands, the written paper. Some of them will acknowledge the written paper and just pass it on to you. Like this one Major Kopus. He was very accommodating. He knew of the agreement to allow us to give ho'okupu without shoes. But when he left and retired, another one came in place and says, well, it may be true, but I don't have it here at this point while they're standing in front of me, so denied. I'm not sure who trains them. I remember asking Laurie that same question, and she keeps saying that they're taking on training of a cultural kind, and when I ask her what culture means, and it comes down to culture for the Army is American culture. Yeah, and they get bits and pieces of every other thing that happens while in their culture. And that was scary. I said, when it comes to Mākua and Hawaiian archeological and anthropological things, we natives should be giving the training. We should be stating the sensitivity of it, not them, the military. Even if you know, there's some things we can share that they cannot even talk about. And I think primarily it's the sensitive. Oh, by the way, I wear this papale so that you know it's not about just me. It's about the many people that have voices unheard about Mākua. So listen to all of us. Anyhow, I've had a hard time as a practitioner because I feel like they don't really want us there, and they've kind of piggybacked with some people who call themselves lineal descendants to say our presence, Waianae at large, and all those people that come through Makua to visit or give respects and hold kuputu, we're all desecrating the property because that's how they feel. But I'm asking, what about their desecration to the land? Is that somehow forgiven just because some alleged lineal descendants say we're desecrating the property? I think firing a bullet into a sacred area is more desecrating than people walking and wanting to learn and be educated by it, by a time that is far gone but still held within the hearts of our people today.
The kind of use that Mālama Mākua has in mind?
We had only an English name for it. English concept was the University of Makua of higher studies, higher spiritual studies, higher whatever encompasses culture. And the culture around Mālama ʻāina, I think that's really important to mention, because the university, as I see it and I feel about it, is about Mālama ʻāina. And so we would be, one of our biggest courses would be the excellence in ordnance removal. How to return an ʻāina back to a sane, safe place after the military or the military services has had it for a long time. And right now some of our members are involved with the EOD. Whenever the EOD has jobs to do, one of our people volunteer and go so we could get first-hand information about it. I don't think the military will want to clean Makua like they did Kaho'olawe, because they didn't really do that. So our people are all ready to take on that responsibility for themselves. But, you know, we've even had kupuna that's been in the military that have come back to say, hey, I'm sorry, I was a part of all of this activities, but now that I'm retired, I've come to my senses and really feel my ʻāina is calling for help. So they've come back to help the Makua return their ʻāina back to safety, and hopefully I think what they wanted to do is to put common sense or spiritual sense back into the military that they were a part of. And that to me is really exciting.
What about the accesses? And if somebody wanted to go along with the access, how do they do that?
Well, first of all, you have to call Mālama Mākua Fred Dodge a few days before the access, so your name can get on the roster. And it was before, let's say 6 months ago, that if you showed up at the place and had an ID and was ready to go, you had your shoes, fulfilled the minimum requirements, you could go along with the ones that had registered their name. Today, they're holding us to the strict letter of the law. If your name's not on the access roster, you cannot go in. However, if you know the right people, you can get by that.
So is Mālama Mākua the right people?
No, we're not the right people, sorry.
So you gotta have connections with the military to get the access.
Yeah, that's one way.
What about access to cultural sites? How has that been maintained?
Oh, that's crazy. The military, through their cultural resources people, are actually denying us access.
Okay, the cultural resource people, are they cultural practitioners or just...
No, they're the Army's version of cultural resource people. In fact, there's 2 right now that is assigned to Makua, and I think the full requirement was that they're local, they're of Hawaiian residency, and they have the study of archeology.
Okay, doesn't qualify them beyond that.
No.
It's a job
I think they're learning their culture while being involved with Makua.
Oh, so Mālama Mākua is providing jobs. They're already an economic engine.
We're also educating quite a bit of people, but sometimes I think it might be to our detriment. But, you know, in the long run, everything balances out. So my job was never to withhold anything I knew.
Okay, getting back to cultural sites, access or denying access to the sites.
They're telling us that with these sites where we really are sensitive towards, they've narrowed it down to the few that's on the front part, within 1,000 meters from Farrington Highway, that they're telling us where we can, or they feel comfortable with us leaving Ho'okupu, and this doesn't satisfy a lot of us. And where we think they want us to give them is the back door on the ground, and that's why we build ahus, so we wouldn't leave food on the ground. It's insulting. It's like the ahu is the table, and so when we don't have an ahu, the next thing we do is go close to the structure and leave it on, someplace that's respectful to us, and they control that, unfortunately.
Well, they've missed a lot of their targets. That's why they call it training. From the helicopters to the machine guns to the howitzers, the mortars, and many of their tracers, or before when they could use it, caused fires and things. But on some of the cultural sites, I noticed that there were bullet holes, and I know they're not now using them as targets, but in the past they have. What has been their take on opening up some of the sites that they've covered up to protect against those kinds of missed the target? Because they sandbag, they covered up, they put plywood over them to prevent potential damage. But we now don't have access to them. So what's happening with those things? Have they said
Nothing.
anything? Nothing. Okay.
They have a future plan when I really press them to open it up. Okay.
But nothing done yet.
But nothing's come.
What's the hope for the future besides the University of Makua?
My hope that they would become really good stewards of the land. Some of what we say and advocate will become a part of their consciousness.
And they'll do it because it's the right thing to do rather than having to go to court and get the judge.
Well, the
to
hope
say
is that
do
they'll
it.
do it because it's the right thing to do and the most fashionable thing to do. Whereas nobody else out there will let them into their ʻāina.
Okay, any last words to the people that are watching?
Have faith, get involved. No matter what your expertise of study, there's always a portion of Makua that can accommodate your interests. And we, as Mālama Mākua, would like to hear your views and opinions, or even ideas about how to proceed in different areas. Aloha.